Hello, fellow toolboxers. We're coming to you live once again. For those listening to recording, I used to have it where every Monday morning I would do an episode of the podcast live on YouTube, Instagram, and on LinkedIn. And it was pretty neat. It helped create an audience, but then I got really busy with kids and waking up and all this kind of stuff because I do it at 6 a.m. Monday mornings. But let's see if we get started all over again. It was a lot of fun. I was able to wake up this early to earlier, but now to catch up on this. So we're going to be doing this live. If you have questions watching live show, let me know. But for the most part, usually the biggest audience goes on a recording at their own, calendar time and all that kind of stuff. So let's set up the show and have it just as always. Some heads up that we have to add is first and foremost, the EB1A course is out. We've had a lot of people who had asked us about extraordinary ability cases. They want to learn that. So I finished a recording session and course online course with redacted copies of examples of things which you could access if you're it's a premium part of the program. But if you're a Circle.so community member, only lawyers could join that. Then you could just log in and on the left side click on the EB1A option, and it'll give you information about signing up and all that. So that should be really cool. And it comes as a combo package, which includes the O1 seminar as well. So that's something that definitely would recommend doing just to get your process started when it comes to O1 cases. But the package for the EB1A comes with mentorships. The O1 doesn't because I don't do O1s, but the EB1A portion we comes with the office hours. The main things I'm going to talk with, we get you up and running on those. The O1 was a seminar recorded, a live seminar with top immigration lawyers in LA. So it's that I've had that recording. I wanted to share that with you so you have it. But that's a cool one. It's right there that I definitely like to check out. Also, I want to thank our sponsor for this episode of the program. I recently caught up with the folks at eImmigration who had shared a big announcement hot off the presses. Have you heard? eImmigration is now integrated with VisaLaw.ai. Over 10,000 users can now connect their eImmigration account to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, entire case package directly with their case management system. This case management means modern drafting, so you can build stronger cases faster than ever. The combination of eImmigration and VisaLaw.ai means that what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLaw.ai. So definitely thank you to Serenade for the great work that they're doing. I appreciate them sponsoring us and the magazine. Quick note is we're going to go through a top 10 today. 10 things I've learned in last couple months, but hopefully I'll make this a weekly again. Having said that, I'm gonna have these notes I'm taking. My assistant's gonna put them in the show description when this goes like it's not the live show, but later on we update it. So if you go to the YouTube page, for example, which is the best place to go for all this stuff at once, and check it out there, and you'll be able to just check out what's going on and have links to it. So because there's so much specific things I'm saying, having links to what we're talking about is going to be really important. Some may not have links, but hey, it is what it is. But having said that, none of the information provided here is intended as individual legal guidance. Please consult with an attorney about your case. So, okay, let's get the show started. Have any initial stuff I got to talk about? That's the big stuff. Join the community page if you're a lawyer. Okay, so number one has 5 different parts to it. So I should probably say Department of State. So it's really top 15 or something. But first things first, uh, definitely whenever you're doing a consular processing case, which I know a lot of immigration lawyers don't do, but when you do, check the visa reciprocity chart. The visa reciprocity chart is a Department of State website, and it lists every country and how they expect their documents to look like. So it's very important to have that for any kind of work you're doing with USCIS or with UIR because it has descriptions of how birth certificates and stuff look like, marriage certificates, and how to get them. But they update this without telling us. And recently, we had a situation where for Pakistan, for all the time I know, they didn't ask for police certificates from Pakistan because they didn't accept the documents. For example, they didn't accept from Iran either. So there's several countries out there where they just say don't bother getting the police certificate because we don't accept it. But one of my clients got it. I was like, oh, that was unnecessary. But I just went on the website just to double check, and I'm like, oh wow, it's necessary now. So like between in May sometime we had to submit a case in April there without it, but in May sometime they changed it, updated where they say Pakistani police certificates are required. So one is if you have clients in Pakistan, get it. If you have cases pending and have been processing, not in processing, but like getting interview schedule in Pakistan can take a year or two sometimes. Probably better to get that in preparation for the embassy interview. But I guess the most important takeaway is you constantly have to check the visa reciprocity chart every time you get a new case, especially if you're doing constant processing. And because these they don't tell us when they make changes. So that's number one. 1A. 1B change they did tell us is the State Department is letting go of, I don't know, 1,300, 1,400, 1,500, something like that, staff members. They say it's U.S. staff members of the Department of State, but inevitably is going to affect consular processing, how long things take. Pretty crazy move out there. Usually, diplomats and Department of State employees, especially longer time ones, have some sort of protections from being fired, but the administration is having a lot of success in the Supreme Court, having the ability to do this. So I'm sure there'll be lawsuits on it, but that's something that's happening. Number 1C, a good colleague on LinkedIn. I 100% recommend following this gentleman. First name and last name, I'm going to butcher him, but he's really good on his immigration journey in India. His name is Gananamukan Senthor Jothi. I've spoken with him before. Really good guy, but I recommend following on LinkedIn because he's constantly putting information. I'll have the link for his page, but he made some note as important changes in passport collection procedures for U.S. visa applicants in India, effective August 1st, 2025. A third-party representative passport collection service will be discontinued to ensure the safety and security of applicants' passport documents. This is really important because you can't have other people pick up your documents now. Applicants must collect their passports in person. Please note, passports for applicants under the age of 18 must be collected by a parent or guardian who must present an original consent letter signed by both parents. Oh boy, it's a lot of work. Or 3, scanned or email copies of the consent letter will not be accepted. Oh boy, premium processing, that's probably the way to go. Delivery is still an option. Applicants may choose to have their passports delivered to their home or office for a nominal fee of $1,200 per applicant at their discretion. For more details, visit their page. That's really important. It's because if you're going to do Indian cases, that's when it pops up. And then 1D, important update, interview waiver program for minor children under the age of 14 for China. All applicants who are under 14 years of age and are applying for a non-immigrant visa at the U.S. Embassy or a U.S. Consulate in General China must schedule an interview and appear for the interview with at least one, probably means the parents. The update means that minor children under the age of 14 years can no longer use the interview waiver process. So it's a special Chinese thing where they're getting rid of interview waivers for children. They must also bring the originals, not copies of the following: minor's birth certificate, household registration book, the Hoku, if applicable, at least one parent's identification document, passport, or Shen Fenzeng, ideally both parents' current and former passports. Current and former passports? Wow. Parents' marriage certificate, if applicable. So this is, I know, right, it's not sure if this is a trial run for other missions or what, but that's what's happening for DS-160. So that was number one. A lot of changes happening in the consular processing section. You have to keep an eye out because they don't really, if they give notices, it's like on a Twitter page. They don't give like, there's got to be a better information delivery system because you look like you don't know what you're doing. You might have done 100 Chinese cases and then this happens and like a client's like, oh, you didn't know? I'm like, no, don't tell us that easily stuff. Very annoying. All right, number 2, CBP, when you're having issues with them, you want to contact them. Typically, I would just call the watch commander, but the last couple times I did, they're pretty annoyed. And then a colleague put me up on this that there's a website called, I wish I remember which colleague it was to give him a shout out, but there's a website called Professionalism Service Managers. I'll have the link in the show notes to cbp.gov/travel/customer hyphen service slash professionalism hyphen service hyphen manager, if you could write that down. But it has a list of various airports, ports of entry, along with the phone number to call. They say professionalism service managers, PSMs, are the primary point of contact to address concerns or comments about the inspections process of international travelers. For questions and concerns, please request to speak to a supervisor. So I haven't called this yet, but I'm not sharing my screen there so you can't see it. But essentially, it has almost all the airports and ports of entry with phone numbers to call. So that's something important to have. Number 3, adjustment of status discretion denial. And this is something that's going to be up and coming, obviously, on new administration. There was a Second Circuit case that came down uh, where this woman had her adjustment of status based on being a parent of a U.S. citizen denied. And so it was pretty scary. And a part of it, they said, like, let me find the parts. So they denied it based on unfavorable discretion, which is like this open-ended thing. And the circuit courts say you can't review discretion when they do it. So it's really annoying and scary. The things that claimed was unauthorized employment, so unlawful presence and stuff like that. They had come to the U.S. and then, but I mean, what they wrote here, the circuit courts write it. It's kind of weird, but there was an immediate relative petition, again, as a parent of a U.S. citizen. USIS denied application, basing its decision solely on discretionary grounds without making any determination on statutory eligibility. The agency identified several factors that weighed against granting the application, including that the applicant, quote, blatantly disregarded, quote unquote, the outstanding removal order. So, I mean, if outstanding removal order, that could be a thing, and remained in the United States in violation of US laws for 30 years. So that's like a million people or millions of people. Um, and that she incredibly professed ignorance of the removal order during her interview for her adjustment of status application, despite having been provided a copy of the order when it was issued in 1995. I've been doing this a lot of years. Most clients who've had removal orders that they don't know they had one or they don't understand it. So it's kind of harsh. It makes it seem like, oh, they didn't know. They're expecting a lot from people. They should know, obviously, but that's not something that shocks me. Additional negative factors, which is this included Gia's or the applicant's 3 convictions for disorderly conduct, and I think that's what got it. 3 convictions for disorderly conduct, which demonstrated a disregard for criminal law and her 20 plus years of unauthorized employment. So 20 plus year unauthorized employment has never been an issue. But on the plus side of the ledger, the agency primarily considered her status as a mother of 2 adult U.S. citizens. But because they were born while she was already in removal proceedings, her ties to them constitute after acquired equities and were therefore given less weight. So I think the removal proceeding is bad. But the thing about this is she was probably trying to get an I-130 approved to go tell the court to like reopen the case or do that kind of stuff. But that was pretty nasty. Then add insult to injury, there was a BIA decision, matter of Gonzalez Jimenez, and the facts are worse than. But when you read BIA decisions at the top, it says like the major points of it, and so this is bad for everybody because our clients have these kind of scenarios a lot. But the person was like got DUIs and stuff like that. Let me read it again what they did. But they had like a bad history. So like bad facts make bad fake cases is one of them. But essentially at the top it says use of a false or stolen social security number and providing false information on tax returns are negative considerations that weigh against a favorable exercise of discretion. Now this is the BI context, the court, all that kind of stuff, but USCIS use it too. When a respondent seeks to excuse conduct by claiming to have relied on professional advice, the respondent should submit evidence of the specific advice given and explain why it was reasonable to rely on such evidence. So be mindful if you're sending emails out to clients and you say one thing and may be wrong, is to come back at you because of this decision. But the use of false or social security numbers, clients don't typically have stolen security numbers. They may like make up one sometimes, which might be someone else's. That becomes an issue. And then here, I think they were using dependents that they didn't have or shouldn't have to save money on taxes. Usually, the problem we have is they don't file taxes. So now I'm pushing clients to file back taxes because discretion is such a factor. And so, you get the ITIN triggers stuff on a new Doge stuff. It's a hot mess, as you all know, the immigration system. But hey, be aware, this is what we're dealing with the next many years. Number 4, USCI is doing tenant verification. We had a colleague share, or I saw some post where USCIS had contacted, called, and emailed a landlord to ask for the bona fides of the tenant. So they are going that far. Obviously, they're probably doing that in the extreme cases because it just takes so much time. And every marriage case I've had, they had so much evidence that's like no point in doing that. Number 5, RSV responses. So we're getting a lot of people contacting us where they got a request for evidence and they mailed it to USCIS and had signature confirmation, all that kind of stuff. And then they got a denial for not going through. So that really bolsters the fact that you should try to upload these online. And if you have the option of sending the online system, we've pretty much gone 100% if possible, do things online. USCIS, we do it. For my whole career, I avoided it because the online system was a mess. But once you get into it, it becomes pretty smooth. And the good thing is the ability to upload documents. But be mindful. I had a person contact me. They uploaded their documents and it was denied. And what happened is apparently when they uploaded it, it was a partial upload or something. So when USCIS got it, they didn't get the whole file and they just denied the case for improper RFE response. So what's very important is once you do upload it, there's a button to download again. You click on the name of the file so you can see what's in there. And once you submit it, click on it again to make sure what you submit gets downloaded. It's a full copy just to double check. So if there are issues, you can try to fix it up as soon as possible. So that's something to tip it to know. Number 6, another con, Andrea Matias. I definitely recommend following on LinkedIn as well. Former Olympian. LinkedIn.com/in/ADMATIAS. Adam Andre Matias. I'll put him. I hope I'm pronouncing his name right, but I'll put it in the show notes. He had a good post. It's very interesting. If you're on OPT, don't work remotely from outside the U.S. He was hired in the 11th hour by a student after he filed for his STEM OPT extension. The problem was that USCIS knew that he had spent over 100 days outside the United States during OPT. The student decided to go to India, Japan, while still reporting to work in the US. He was working, but abroad. The job was fully remote, and he got the thumbs up from his boss and the International Students Office. So they never rely on the International Students Office, obviously. So he was completely surprised when USCIS pushed back. He didn't understand why the agency claimed his time abroad constituted unemployment. So, you only get 90 days of unemployment. The USCIS policy manual states in relevant part that time, quote unquote, time spent on overseas counts towards the F1 student's aggregate maximum allowed period of unemployment. I haven't read the policy manual, so I'll take his word for it, but you put in quotes, you're allowed a maximum of 90 days of unemployment while on initial OPT. Because the student had spent over 100 days working remotely from abroad, USCIS deemed him to be unemployed, a violation of status and, you being out. So that was a kind of a crazy situation that happened there. So that's why, listen to this podcast, following this stuff, you got to study immigration constantly because I wouldn't have thought about that, frankly. It hadn't come up. But I was like, oh, yeah, that's true. That makes sense. So, so I'm glad I could share it with you. Speaking of sharing stuff with you, I want to remind you that the Toolbox EB1A course is out. The E2 course is coming. We used to do this live. I'm recording that soon. I'm going to put it out there too. Really get involved in EB1A. Know it. Have this part of your toolbox that expands your practice, and you get mentorship, time to talk with me about pretty much open-ended anything you like to do in our office hours and everything. So please check it out. If you're already part of the community page, circle.so. It's a link on the left side column for joining there. If you're not a member of the community page, let me know. Email me your bar information to info@immigrationlearnerstoolbox.com. And also let me know if you want the EB1A course. I can send you information on that, get it started. But now is this, don't wait to get things started as soon as possible so you get your life up and running. Again, that's the EB1A course. The E2's coming, so let me know if you want that. All right, let's go to number 7. This is an interesting one. You all using ChatGPT essentially now to learn more. Every year I get like 1 or 2 diversity visa cases where we're doing constant processing adjustment status, and I got one adjustment status. And so I was doing the initial stuff, and I told the client we got to pay this initial fee, and he wasn't aware of it and stuff like that. And I hadn't done this last year, so I'm like, let me see what ChatGPT says it was again. And I looked it up, and it was a huge mistake. So I asked ChatGPT what the fees are for diversity visa lot if you're doing it in the U.S., and it says the adjustment of status fees. So then I responded and say, no, there's a fee you have to pay to KCC. It said, no, there's no fee. I'm like, no, there is. There's a fee if you want to. And it said, no, it's only if you're doing constant processing. You have to pay constant processing. I'm like, no, you're wrong. And then so I went to the Department of State website. There's a fee you initially have to pay to the KCC and say Kentucky whatever center and say that you're going to do the case adjustment status. You write them, it's like a money order ever sent or something like that. So I sent the copy pasted this in the URL, and it's like, oh yeah, you're right. That is true and stuff like that. So I probably updated their system, but it just goes to show that ChatGPT is unreliable. I'm sure a lot of people are doing their own cases, getting completely screwed on that. But the laws, you got to know the law and study it and know it because the nuances there. Number 8, travel ban. Okay, so this is another important one that's unfortunate. So if you're one of the people, your client's one of the people that hit with a travel ban, there is a national interest exception included, like essentially a waiver. Last time around, there was no waiver. It was just nonsense. And this time around, it seems like it's going to be the same. So Ayla reached out, doc number 25062505, says in an email response to congressional inquiry on the implementation of such national interest exceptions with Ayla, the Department of State provided the following information. This is public government information, so I should be able to use Ayla stuff online. Applicants seeking a national interest exception must first apply for a visa before the Department of State can make a determination. We anticipate the national interest exception will be very rare. The department will make a determination regarding a national interest exception on a case-by-case basis if the applicant is first round eligible for the visa. The travel must advance a U.S. national interest, routine purposes of travel, including visiting family members in the U.S., routine business travel, employment, or studying in the U.S. would typically not be considered to be advancing a U.S. national interest. There is no application for a national interest exception that will be considered by the consular officer during the interview. At the time of the application, affected applicants should be prepared to explain to the consular officer why such an exception is in the U.S. national interest. It must be found otherwise qualified for the visa and demonstrate to the satisfaction of a consular officer that they are not a threat to U.S. national security or public safety. So that was like a annoying one there, but that's a reality of this waiver system. Now there are some waivers like Immediate relatives are exception. It's not a waiver, it's an exception. If you're from Iran, if you're a minority that's like religious or ethnic, potentially they'll do an exception. Who knows how it's all going to play out? It's just really nasty. Number 9, they're gonna be taking away duration of status. So if you're F1 students and you're in the United States, you have a thing called duration of status. There's no end time for your ability. It's not that like, the I-94 doesn't have an end date. Last time around, Trump administration tried to take it away, but they were sued. They stopped. They're going to do it again. They're going through the proposal system. Why it's important if you all had a person actually, I saw a person on Facebook asking this question in the immigration group this morning. When your duration of status, you don't accumulate all off of present states. That's the great part. And importantly, if you work with authorization, although it is a violation, it doesn't shut down the duration of status. The only thing that shut down duration of status is a finding by immigration authorities, the courts or USCIS or something that specifically ends the duration of status. So that's a important one because a lot of people on F1 students were able to adjust status and or do consular processing without needing a waiver because they don't accumulate unlawful presence. That's a big one. Number 10, another colleague on LinkedIn, Poonam Gupta, had this. The Department of State announced the creation of a new Office of Immigration Policy. Oh, that's going to work well. To improve access to legal work visas for employers and foreign workers. We'll see. The purpose of the office is designed to streamline employment-based visa programs, improve interagency coordination, and reduce delays in processing applications. The initiative will directly support visa pathways such as H-1B, H-2A, H-2B. So definitely check that out. It's be led by Brian Pasternak. That sounds familiar. Who also heads the Office of Foreign Labor Certification. There's more to it. Another colleague, Poonam Gupta, definitely check that out. And number 10, and I'm going to be doing an interview with a colleague who posted this. They've updated the foreign policy man. It should have been, I guess, the conference at the beginning, but a great colleague over there, Joy Barnett, partner at WR Wolfsdorf, and R stands for Wolfsdorf, and I'm sure the partner with the R always like, oh yeah, no one remembers me. But Wolfsdorf himself is the character of the field, so everyone knows him. But my apologies to the R. Rosenthal. See, I do know. I know. I don't think I've spoken with either of them before, but my job is to try to know as many people as possible. But Jory Barnett, another great partner there, updated. So the U.S. Department of State has significantly revised Section 9 FAM 302.5 of the Foreign Affairs Manual in June 2025 to implement a stricter interpretation of the law for INA 212A3DI, which bars immigrant visa issuance to members and affiliates of the Communist Party or any totalitarian party. Here are 10 key changes. So check him out on LinkedIn, Joey Barnett, Barnett. This post is really interesting. I'm going to go through with him in a podcast coming very soon, so listen to that. But essentially, it's made it much more stringent to get the immigrant visa option if the people have any association with the Communist Party, even basic ones before that would just let it slide. It's getting difficult, as you can imagine. It's all national security stuff. So that's the immigration case in a nutshell. I'm going to have to take better notes again to try to come up with another 10 in the coming week. On Monday mornings, we'll try to bust this out and keep it going. I got 2 interviews coming to USCIS this week. I don't like driving out there because it's too far. You never know what the world's going to have at USCIS. So far, the interviews have been good, and they've all got approved pretty quickly. I have one case in the Northeast is still pending, but thankfully they didn't pick him up or something. So our standards are really low. Just don't like detain people that have a right to get a green card. We're happy. But having said that, the EB1A course is out. Learning EB1A, E2 is coming out. Learn that too. Our marriage green card course, which teaches consular processing, is there. Just email me. Get your future started. Fast forwarded. Get mentorship. That's the main thing about this. Instead of taking years to learn something, learn it really fast. It saves you your life. And also have a mentor, someone that can hold your hand, not just some group or post you could do, and hopefully some response. Someone who's like has their skin in the game. That's what I'm here for. Info at immigrationlawyerstoolbox.com. These courses are just for lawyers, not intended for non-lawyers. But having said that, thanks so much for listening. Hope to see you all next week. Bye bye.